The most recent legislative session brought about some changes. Many of those changes have the potential to impact ESDs. Some were highly publicized and very controversial. Others kind of flew under the radar a bit, but still have every bit of opportunity to impact your ESD. To present on two of these emerging issues, is what we're calling them, is a man who really needs no introduction. For our longtime safety participants, you'll recognize Mr. Howard Katz. He's an attorney out of Houston. He's been with safety from the very beginning. He's spoken at many conferences and workshops around the state, practically wrote the book on ESD law along with John Carlton and Ken Campbell, the other two of the three wise men, as we call them. Howard's currently of counsel at the law firm of Kovler and Katz in Houston. He represents many ESDs, particularly in the Harris, Fort Bend, Galveston, Montgomery counties. And we're very glad to have him tonight to present on two of the most interesting and impactful issues from the last session. Howard, without any further ado, I'll let you take it away.
Well, thank you, Clay. I appreciate it. These are two very interesting topics that have come up. You mentioned one came under the radar, disclosure of interested parties in contracts. That one kind of came under the radar. It was discussed, it was out there, it was looked at, but the rules that came in affecting those contracts took a while to come into effect, and we've had to address the rules, and we're trying to get through that, and we'll address that in the presentation tonight. Concealed carry, open carry handguns certainly affects ESDs, as it affects all government agencies, but of course it affects every citizen in the state, and so we'll address that also from the ESD perspective. We're going to address the HB 1295 first, and I am going to read the purpose of the statute and the intent. A government entity may not enter into a contract with a business entity unless the business entity submits a disclosure of interested parties to the governmental entity at the time the business entity submits the signed contract to the government entity. Does that sound like that was written by the implementation of the statute is done by the Texas Ethics Commission? So what they have stated is that this section, this statute, requires a business entity entering into a contract with a government entity to file with the government entity or state agency a disclosure of interested parties at the time the business entity submits the signed contract. That's kind of an evolving process. The original obligation, however, is imposed on the business entity. They're the ones who have to register with Texas Ethics Commission and send their registration to the ESD in this case. Now, most are doing it at the time they send in their proposal or contract. It doesn't actually say that, but I think most vendors are just trying to get it out of the way. We'll get into this a little bit later, but the Ethics Commission has kind of said now that the time the ESD has to acknowledge the disclosure form is when all parties are bound by the contract. And we'll get into that a little bit. The rulemaking entity for implementation of HB 1295 is in fact the Texas Ethics Commission. They're the ones who adopt the necessary rules to implement this statute. They're doing a very good job. They are allowing parties to submit comments and suggestions. The first rules were done for December 24th, 2015. They were done fairly quickly, but they were not as comprehensive as they would need to be, which is understandable given the time constraints that the Ethics Commission had. In February 2016, the Texas Municipal League, along with other agencies, had meetings to address these disclosure laws, identify some problem points, and try to propose some guidance on the Commission rules, both for purposes of our clients and members of SAFE-D, but also to make it more usable for the government agencies. And we thank Texas Municipal League for taking the point on that and helping guide the comments that were made to Texas Ethics Commission. So the bill itself, again, the purpose of it is the requirement of a business entity entering into certain contract with public agencies, including ESDs, that they have to submit a statement of disclosure of interested parties. Now, those definitions will be coming up shortly. But note the second restated prohibition in the comment. A government entity may not enter into a contract with a business entity unless that business entity submits the disclosure of interested parties. That's a key point. The transparency of the business interest in the contract is obvious. Yes, we want there to be transparency. We want to know who are making contracts with public agencies, who are getting public funds. No problem with that. However, it is a government entity that can run the risk of being non-compliant with the statute, not because it didn't file a form, but because the business vendor didn't. We're going to address that in some detail later on. The issue is, and as you see, it says a government entity may not enter into a contract. Does that make a contract that is non-compliant with HB 1295 void? Voidable? It's not clear. However, my suggestion would be that you treat that as a potentially void contract and therefore do not chance the risk of that contract being declared illegal. The HB 1295 applies to contracts that were entered into after December 31st, 2015. So we're operating under that statute now for contracts being entered into now. There's a two-pronged test as far as whether this statute applies to a particular contract. If a contract requires action or a vote by the board, in this case by the ESD board, it's covered by the statute. Or if the contract has a $1 million value, it's covered by the statute. Those are two independent prongs. It does not apply to, and I'll just, research contract for a college, interagency contract for state agencies involved with higher education, contract related to health and human services. The last one, however, is potentially applicable for ESDs, a contract that is less than $1 million that is delegated by the governing board, by the ESD board, to staff to approve and sign the contract is not covered by the statute. As indicated more later, we'll address that. There's some pros and cons to adopting that procedure. But again, that is an exception to the statute. Definitions is kind of where the details are as far as the application of the statute. Now, some of these where it says new/TEC clarification are the result of the Texas Ethics Commission promulgating revised rules to that December 2015 original set. So a business entity includes an entity through which business is conducted, regardless of it's a for-profit or a nonprofit entity. So nonprofit entity automatically will bring into the coverage volunteer fire departments, volunteer EMS services, and for-profit agencies as well. Something that was added is that the term does not include a government entity or a state agency. So interlocal agreements between an ESD and a city or a county or a state agency, they are not covered by HB 1295. Contract was amended also to simply say that it includes an amended, extended, or renewed contract. We had requested, and TML had requested, that the Commission consider amendments to contracts as being outside the coverage of HB 1295. So a change order on a construction contract or an amendment to a contract, that would not be covered. That was not accepted, and therefore any contract, including an amendment to a contract, like a change order, is still covered by HB 1295. So that very well mean that even though the first contract was done under the HB 1295, the form was submitted, if the contract is amended, if the price is changed, if there's a change order to the construction project, a new HB 1295 form likely needs to be filed. Government entity includes basically all local jurisdictions and state agencies, including ESDs, covered by special purpose districts. Interested party. The old rule, and you can look at it there, the old rule was very confusing, very cumbersome. Anyone who has a controlling interest in a business entity with whom a government entity or state agency contracts, or who actively participates in facilitating the contract or negotiating the terms of the contract, including a broker, intermediary, advisory, or attorney for the business entity. I like reading it because I think sometimes when the legislation is written, nobody's really reading it out loud to kind of hear what it says. That's very confusing. TEC did amend that, so now an interested party means person who has controlling interest in the business or is an intermediary. Now those two terms will also be defined, but that makes the test much easier. So the new TEC clarification of controlling interest, a person who owns more than 10% of the business, either the stock, units, partnership interest, anything that constitutes the incident of ownership, if it exceeds 10%, that's a controlling interest. Membership on the business entity's board of directors, or if they're an officer, again, is defined as a controlling interest based on how many members of the board there are or how the compensation to that person may be. So essentially, if you have anybody that is a member of a board of directors and there are fewer than 10, they have a controlling interest. If they have more than 10, but they are one of the top 4 compensated officers, they're covered, they're defined as a controlling interest also. And again, that's not the ESD issue, that's the vendor's issue. They need to make sure that they fill out that form correctly. Now, intermediaries, where it gets a little interesting, that was also redefined by Texas Ethics Commission. So intermediary is a person who actively participates in the contract, negotiating the contract, either as an attorney, a representative, or an agent of the business entity. But here's where it gets more clear. They have to receive compensation from the business entity for that participation. They themselves have to communicate directly with the government entity or state agency. And they're not an employee of the business entity. Now this became significant because at the business entity, you don't know how many hands a particular contract may go through. You have, for example, a number of sales representatives who may interact with the fire department or the ESD. If they are not covered by one of those 3 sections, they don't have to be disclosed in the disclosure of interested parties. And that was a real issue because in-house counsel, for example, at the vendor, they may very well look at the contract, they may talk to the ESD, but if they are employed, then they're not covered. And so you don't have to go trying to track down any number of people who may have participated in that contract. That's a much more usable, sensible definition of intermediary. Now, I mentioned about the staff exception when if the ESD delegates the authority of the making the contract. So remember, HB 1295 is a process that applies to any contract that requires an action or vote by the governing body. So if an ESD is going to vote on a contract, it's covered. Or if it has a value of at least $1 million. Now the Texas Ethics Commission has adopted a rule that says action or vote by a governing body is not included if the governing body has legal authority to delegate to its staff the authority to make the contract, and if the governing body has in fact delegated to its staff the authority to make that particular contract, and if the governing body does not participate in the selection of the business entity. Now, I can see some larger municipalities, perhaps even water authorities, some of the larger ESDs might possibly be able to get under this exception if they feel a need to. But as I note down there, caution that most ESDs, in fact, do operate through their boards of directors, boards of commissioners. They do vote on whether a contract will be awarded, who's going to get the bid. They actually do participate in that. If the $1 million threshold, of course, is exceeded, like on a construction contract, it doesn't matter who's making the decision, it's covered by HB 1295. But I would strongly urge ESDs to look at that exception. If in fact there is staff to which these kinds of activities can be delegated, that is something that can be used. But again, remember that number 3, the governing body does not participate in the selection of the business entity. So essentially, it really has to be delegated, and the ESD board no longer is involved in the process. I don't know very many ESDs that operate that way, so if this staff exception workaround is going to be used, make sure council is involved, make sure that this whole process is carefully examined. Because again, void or voidable contract is the possible result. The disclosure has to be submitted on a form that has been promulgated by the Texas Ethics Commission. Anyone who looked at their form back in January or even February, that form has changed, and the form that is to be used is on the Texas Ethics Commission website now. And it goes through the bullet points as to what has to be listed on that form. And again, hearkening back to controlling interest, the board of directors control, the ownership of more than 10% of the company, that's who is entered into that form. And it's on there, you can write this down. The Ethics Commission website is www.ethics.state.ts/what's-new/ELF. Just go to their website and it will lead you to the tutorial, and there's a good frequently asked questions section that can help both the vendors but also the ESDs. But it's really intended to make sure vendors know how to fill out that form. Now, some lingering interpretation issues with the HB 1295 process. What's the value of a contract to determine if it's captured by the statute? Is it over $1 million or not? The statute provides that it applies to contracts that have a value of $1 million or more, but neither the statute nor any of the rules thus far promulgated tell you how to value a contract. So for example, sometimes attorneys, architects, financial advisors work on an hourly basis or on a percentage basis. So at the outset of that representation, there may not be the anticipation of a contract that would be covered by this. Certainly no one's anticipating $1 million attorney fee contract, much as we may try, but that's not the intent. But again, that value can change during the course of the representation, whether it's the financial advisor or other business consultants. They may initiate a contract that perhaps can be delegated to staff and doesn't exceed that $1 million level, but then as the ESD board perhaps gets re-involved with the contract and the representation, HB 1295 can come back in through the back door, which then triggers the compliance on part of the vendor as well as the ESD itself. One question that comes up as it pertains to the relationship between an ESD and its service provider, is 1295 triggered if the contract is entered into by the service provider, the volunteer fire department, EMS service. However, where ESD funds are used and the ESD board has to approve the funding of that contract. So, for example, the volunteer fire department does a contract to buy a new fire truck. It's not a contract that is being made with the ESD. So that kind of action and approval and vote by the ESD board may not come into play. However, again, I think that in most cases, well-operating ESDs are going to be involved in that process. They're going to appropriate the funds, and they're going to say yes or no as to the proceeding with that contract. This is further complicated, as many of you know from a couple of sessions ago, that all property owned by a service provider contracted to an ESD, all property is owned by that ESD if in fact ESD funds were used to purchase the asset. So now you get into an issue, is the VFD, is the service provider in fact operating as an agent of the ESD? In fact, if the VFD doesn't own the truck that we just talked about, but in fact is owned by the ESD, does that kind of get back into 1295 coverage? Now, the consensus of the TML working group was that those contracts are not covered by HB 1295 because they're not being made by the ESD itself. That may be very well true, but I'm going to fall on the side of over compliance, and my suggestion would be that even contracts that are made by the VFD or EMS service provider that is involving district funds, where in most likelihood the ESD board is approving that purchase, that 1295 be adhered to. Similarly, contracts between the ESD and its service provider are covered by HB 1295. So new contracts that are made after January 1st, 2016 between an ESD and its service provider will come under HB 1295. Similarly, any contract that is made by, or any amendment to the contract that is made by the ESD and the service provider also triggers new compliance with HB 1295. So for example, if a budget is amended, the budget that's approved by the ESD for the service provider during the course of the year, yes, I think HB 1295 is triggered again because it covers amendments to contracts. As a cautionary note, HB 1295 and the Government Code section are notice and government transparency legislation. It does not take the place of chapters 171 and 176 of the Local Government Code. Those ethics requirements and conflicts of interest and nepotism statutes still apply. The disclosure requirements of HB 1295 does not take the place of the Section 171 and 176 Government Code ethics filings. So that's critical to remember. Some vendors, I understand, are thinking that that's what this form is for. It's to show that they have no interest in anybody who's on the ESD board or a member of the service provider. That is not what it's for. Those sections, those chapters 171 and 176 of Local Government Code still apply. I think that concludes our coverage with regard to HB 1295.
I think we'll just keep going on to the handguns and the open carry, and we'll save all the questions for the end, probably. But real quickly, let me go ahead and remind you over my voice over here that you can call us at 512-251-8101. Email us at safed@texas.net. You can text me 512-567-0857. Normal text messaging rates apply, and I can't answer that phone number. Or you can fax us at 512-251-8152. There's our graphic, and without any further ado, we're getting some questions in, but we're going to go ahead and go straight into open carry. So go ahead, Howard.
Okay, well, handgun laws, that of course was certainly not under the radar. That was about as a fractious piece of legislative activity that we've had in a long, long time. We've had concealed carry for many years now, but effective January 1st of this year, HB 910 created the authority of a person who is licensed to carry to openly carry a holstered handgun. Now, the statute itself, the law itself, of course, is statewide. It affects all the citizens of the state of Texas, but there are aspects that affect ESDs that we'll be coming to very shortly. Now, HB 910 essentially said if you can carry concealed, you can carry open. Unconcealed handguns, open carry, you have to be carried in a shoulder or belt holster. A separate license is not required. The concealed handgun license is all that's required. The eligibility criteria for open carry is the same as concealed. The coursework and all of that. We're not going to go into that much, just so you know that, that concealed carry, open carry, very similar in how they are to operate. I want you to remember, however, that the general nexus of the statute was that open carry can take place in the same place where concealed carry is allowed. Remember that as a kind of a theme throughout the presentation. Now, volunteer fire departments and EMS agencies, those private entities that contract with ESDs, are kind of just like any other employer. They can put up the signs that say, really two signs that say you cannot bring in a concealed handgun into these premises, you cannot bring in an open carry handgun into these premises. This goes through the signage a little bit. I think the word has kind of gotten out as to how the signs have to be done, and they have to be displayed conspicuously. So very often when you go into these private businesses, you see these two signs that are up. Also recognize, however, that an employer has a right to limit employees bringing weapons into the workplace. However, under the statute that was amended in 2015, that doesn't extend to the parking lot. So employees can still keep their weapons in their car properly stored, even if they can bring it onto the workplace. Also recognize, I guess, that the statute allows a business owner, even if they don't have the signs up, to present a person in that premises, not an employee, but a patron, with a card that says essentially the same information that goes on those signs, and by presenting the card, they can request an open carry person to remove himself from the premises, and then if he wants to come back concealed carry, he can. The issue with that is going to be very interesting because since there is not open notice at the time you enter the premises, you now have a question of how are they employing that card? Who are they employing it with? When are they using it? When aren't they using it? So you have issues of possible discrimination and all those kind of issues because of the license issue. Very quickly, sign 1 relates 30.06 of the Penal Code for concealed, and then 30.07 for the open carry. You're likely going to see both signs put up, but it is possible that you may only see a 30.07 sign put up because they want to limit it to no open carry. But remember, the statute theme was that if you can bring concealed in, you can bring open carry in. So that is probably going to still be subject to an AG review as to whether that's discriminatory and whether it's frustrating the intent of the legislation. Open concealed carry is still prohibited in the normal locations. At the bottom, I noted If a private business owner requests someone to leave the premises if they are carrying a weapon, whether or not the proper signs are posted, that is also a prohibited place in that sense. However, it brings in the whole issue. If you don't have the big signs up, why are you presenting this person with a card saying you have to remove yourself? So the discrimination issue again comes into play. Something that we're going to be getting to shortly is one of the places that you can't bring open or concealed carry is to a high school, college, or professional sporting event. So parenthetically noting there, very often you have ambulance and fire trucks and the crews at those events for security, for the purpose of protecting the participants. So as we get into it, you'll see there is going to be a conflict occasionally from where can you have a weapon and when does that interact with the emergency service providers. Open carry is not permitted in these places. And the very last one again is if a business person requests someone to leave. Again, whole question, signs of is there a cause? Is the business owner concerned about this person having an open carry weapon? Is it off-putting to the other patrons? Well, maybe it is, but if the signs aren't up, question is there good cause or no cause for them using the card? And does it get into that discrimination issue? You know, why is this person being given a card and maybe somebody else isn't? Public and private employers, of course, also can prohibit, as I mentioned earlier, their employees bringing weapons into the workplace. That applies to public and private employers. So certainly the ESD, but as well the ESD and the service providers can control their own premises. Where the ESD and all other local governments now get brought into this is government buildings. State agencies and political subdivisions, including ESDs, cannot use 30-6 of the Penal Code to exclude concealed handguns from their government property, whether it's owned or leased. And in fact, there are civil penalties associated with that. One question that's come up, and the thought is that even though it refers to 30-6, that it's referring both to concealed and open carry. There may need to be an Attorney General opinion to clarify that, or whether open carry can be brought onto the government building. There are exceptions, of course, with regards to courthouses and things like that, but that's going to still be kind of, I think, an interesting area to have to cover. So a political subdivision cannot post signs, the 06, the 07 signs, prohibiting entry into the government building unless there is a separate restriction, which would involve courtrooms. Now, at least one county that I'm aware of, and probably more, basically tried to put a courtroom into all their buildings and say, hey, you can't come into any of our buildings with a weapon. Well, that's not exactly how it works. So, for example, you can't go into the courtroom, and maybe you can't be in the corridor outside the courtroom, but you can go to the rest of the building. Similarly with ESDs, for example, if there's a meeting going on, open meetings are exempt from open and concealed carry. But does that mean that you can't come into the building with your weapon? The answer the AG has said clearly is no. Government buildings are open for weapons, but can be limited away from the place where the meeting is taking place. And that seems to make sense with the intent of what the statute is. Now, a license to carry a handgun does not give any special right of access to the government building. So, for example, if you have a fire station, there will be places where there may be drugs and medicine public is not allowed there. And so that would be an area that is prohibited from persons carrying. Similarly with dispatch and with other types of services that are provided by the service provider, they're not open either for either confidentiality reasons, HIPAA reasons, which wasn't discussed very much during the legislative process, but that doesn't give an automatic right, the license to carry doesn't give an automatic right to go anywhere and everywhere within the building, even if it doesn't concern a courtroom or an open meeting. The service providers still have the right to control the operation of their building. The Texas Attorney General, as noted, enforces this provision, and so if a complaint is filed, the AG will investigate, send a notice to that government, and give them 15 days to correct the infraction. Otherwise, those pretty stiff penalties comes into play. Now, government buildings becomes interesting when we talk about our fire stations, our EMS agencies. For example, who owns it? Does the ESD own it? Does the service provider own it? If owned by the ESD, it's clearly a government building and everything we've discussed comes into play. What if the ESD owns the building but leases it to the fire department, in effect provides it to the fire department or ambulance service? It's still a government building, and the consensus is that that is in fact still a government building. Now there's a pending request of the Texas Attorney General to address that very issue, posing the question that if the local government owns a building, and forget about fire departments and EMS, but owns a government building and leases it to a nonprofit, has nothing to do with fire, nothing to do with EMS runs, but leases it to a nonprofit, is that government building subject to the open and concealed carry? That AG has not come out. There's a reference. It's RQ-0097. And when that comes out, that will clarify, I think, a lot of the questions as to the governance with regard to carry into government buildings. But let's go a little bit further. So if the building is owned by, let's just say, the volunteer fire department, it would seem that that agency has the same rights as any other private property owner to permit or prohibit open and concealed handguns on those premises. But the question comes, is that really a government building? And so it gets to, for example, many ESDs have their meetings at the volunteer fire department fire station. At that moment, is the ESD leasing that building for purposes of the meeting, and does then the prohibition on open and closed carry come into play? Very, very interesting dynamics there. And again, the violation of it does have penalties associated with it. Something that came up at the Galveston conference that was really interesting is ambulance and fire trucks, when they respond to a scene, clearly that they're not government buildings, so we're not covered by that section. But what happens with the weapons policy, since now you have widespread carrying of weapons legally and legitimately, if the EMS agency wants to adopt no weapons on our facility, on our ambulances, on our fire trucks, or on our personnel, that's their policy. Well, what happens when the 911 call comes in and they go to a location where open and concealed handguns are in evidence? What happens with a patient who has a weapon and here comes the ambulance crew? Who takes possession of the weapon at the scene? So the different options that were discussed is, does the EMT call for law enforcement to come collect that weapon? The section 411.007 allows a peace officer to disarm a person covering with a weapon. You get into those issues, however, we have to be concerned, is EMS service being compromised by waiting for law enforcement? Do you give the gun to a family member, and what happens if that leads to some bad activity? And then what happens when you get to the hospital and you want to give the gun to the ER nurse and they say, get that gun out of here? So there are issues that come into play with this that we have to kind of put some thought to and probably develop our own thoughts and policies with regard to those kinds of circumstances.
Okay.
Thank you.
Thank you, Howard. We've got some questions, so we're going to jump right in after I prompt you one more time on how to get your questions into us. You can call us at 512-251-8101. Email us at safed@texas.net. Texas is spelled out. Text me right here in the studio, 512-567-0857. And you can even fax us at 512-251-8152. Let's start out with a question regarding the ethics, the contract reporting. This is from one of our friends up in Parker County, up in North Texas. We issued a purchase order for SCBAs for $200,000 from a vendor, but we also executed a lease purchase agreement through a third-party company. Does both the vendor and the financial company have to file 1295 forms?
That sounds like you got two separate contracts, one for the purchase and one for the financing, and that would mean, yes, both entities should be doing 1295 disclosures.
Excellent. So whatever, the forms are tied to the contract, and if there's each contract needs a form?
Well, that's exactly the point. You would think that a single project can have a single 1295 application. And that was one of the requests that TML had made to the Texas Ethics Commission, was to treat the contract as the whole catharsis of the process, but that did not get incorporated into the new rules. So you can have a single activity, building a fire station, or buying an apparatus, as this question involves. Each vendor, I believe, needs to do a 1295 because those are separate contracts. Interesting, though, my guess is that the purchase may have been made under a cooperative purchase agreement like HJC or Buy Board. TML, and we tried to get Texas Ethics Commission to give an exception to those kinds of purchases that have already gone through a process and a 1295 between the vendor and HJC, say, and so does it still have to be done by that particular vendor? That did not make it into the rules. So even though it may be a purchase that wasn't put out for competitive bidding, that purchase still is going to be a 1295 contract.
Okay, let's on some of the 1295 stuff. Let's get to some basic questions here. If there are no interested parties, do you still have to, even if there is no interested parties, do you still have to file the form? So
that's I think a error in view by the vendors. There's always going to be an interested party. Yes, we have seen a number of these 1295 forms come in where it said no interested parties. But remember what an interested party is under the 1295 form. Somebody who has controlling interest in the company and somebody who is an intermediary working for that company. The likelihood of there being nobody that is involved in the contract that fits into one of those two categories, to me, is very remote. Now, if it in fact is true that somehow there isn't anybody that has controlling interest, there isn't anybody who acts as an intermediary, then the form still has to be filed and the vendor would put in no interested parties. I would look at that. I would refer that to counsel to make sure that that form looks okay. Again, just to protect that contract later on.
okay, where is the form? We got that one from before. You addressed that. It's on the Ethics Commission.
It's on the Ethics Commission. The form is not mailed. It is not emailed. It is entered on the Ethics Commission site.
Oh, really?
And that's where the number is obtained, and the acknowledgement is done by the ESD as well.
So there's no actual, you can't just print out one of those forms?
No, you can print out that form, and that form can be and should be sent to the government agency, but the paperwork between Texas Ethics Commission and the vendor is very little. It's all entered through their site.
Okay.
But the form itself has to be filled out and signed, and that form is submitted to the government agency. When they get it, they then acknowledge it on the TEC through the electronic filing.
So it's filed with the Ethics Commission as well?
It's acknowledged by the ESD on the Ethics Commission site.
Okay.
The form itself that's sent to the ESD, that form as such is not delivered to the Texas Ethics Commission. The information is only entered on the site. The form itself is sent to the ESD.
So the vendor goes on, fills out the form, it's electronically filed with the Ethics Commission, and then something is mailed to the ESD acknowledging.
By the vendor, right.
Okay.
When the ESD gets the form from the vendor, it may come in with the contract, it may come in with the packet. That's when the ESD goes onto the site and acknowledges that they have that form, and that completes the circle. There's first a number assigned by TEC to the vendor, there's a distinct number assigned to that contract, and then there's an acknowledgement done by the ESD. That's your circle of operation.
Okay. So that would tie into our next question here. How do you know if the business entity filed the form, you would get that acknowledgement?
Right.
So if there's no acknowledgement, you should assume they haven't done it?
Again, remember, the form itself is filled out and submitted to the ESD. The vendor has already gone on to the website to get their distinct number and get their registration number. That form is then sent to the ESD. The ESD gets that paper form, and then the ESD goes on to the site and acknowledges receipt of that form.
Okay.
And there's a little. The Ethics Commission has said that the acknowledgement by the ESD has to be done, of course, all agencies, within 30 days after the contract is received. That is still in the rules. Now, in the promulgated revision, it says when the final party to the contract has agreed it. So when all parties are bound by the contract, that's when the ESD would do the acknowledgement. But that's only promulgated. Those rules have not yet been approved by the Ethics Commission. They've only been promulgated.
Okay. Let's go to a text question here. 1295 exempts a contract dealing with health and safety, and that has a total value that is indeterminate. If a contract between an ESD and a provider that depends on tax revenue that is variable and subject to emergency expenses, is that contract indeterminate and thus exempt? So if the contract says that it's depends on tax revenue and is subject to the actual emergency expenses, would that be indeterminate? Is
that's a really good question. We kind of touched on that during the presentation as to how do you determine the value of a contract. But remember, the contract, there are two aspects of that prong that triggers the compliance. One is, does the ESD board approve and vote on that contract? If the answer is yes, the contract is covered by 1295. The second prong was the $1 million. So if the ESD is going to take up a contract and say, we approve this contract, regardless of the value, 1295 is triggered.
And that exemption wouldn't apply.
That exemption would not apply. But it's a good question because dealing with third-party vendors, sometimes you don't know what the value is going to be. And therefore, my suggestion would be you treat them all as 1295 contracts if the ESD board approves it, votes on it, and does not delegate to staff the actual approval and signing of those contracts.
Let's repeat once more for everyone out there. The conflict of interest laws still apply Local Government Code chapters what was it?
171
and 176. Those still apply. We do have a question. If a board member is elected, by law cannot be related to anyone in the fire department, how could the fire department have a conflict of interest with the ESD? I guess they couldn't, but
Well, to me, that's a 171, 176 contract. It's kind of beyond the scope of what we're doing here. The key point is that HB 1295 is a separate matter. There's always going to be 171 and 176 concerns that have to be acknowledged by members of an ESD board when they do contracts. Again, HB 1295 is a transparency statute that relates to local government and their contractors. The 171, 176 is conflict of interest, which is unrelated to the HB 1295 coverage. So we may need to do a presentation at some point on conflicts of interest. The key point, and the reason I had it in the presentation, is some vendors think this is the conflict of interest statute. It is not. This is simply a disclosure of interested parties. The conflict of interest under 171 and 176 is a whole separate issue that can still be triggered even if 1295 is complied with.
okay. Kind of asking, I guess, what counts as a contract? Contract expired with VFD before this year, continuing on as is basis. So there's no, I guess there's no, the contract's expired, they're no longer under the contract, and they probably need to redo their contract with
Yeah, the contract has to be redone at some point. It's probably being done, continued on an extension, and I think HB 1295 would need to be complied with.
Okay, even if it's an extended contract from before the first of the year.
Well, most likely there's been some discussion and amendment with regard to the budgeting and the financing, so it may be something that that needs to be addressed. But certainly moving into the new contract, HB 1295 should be looked at.
Okay. So a contract under 1 million, how much board involvement does the count? So that's
The staff delegation.
yeah.
Again, it's a slippery slope. You've got to be careful. You essentially, I think, in order to be fully exempt from 1295, you're looking at a situation where the ESD board is totally removed from that contract. They're not voting on it. They're not continuing their involvement. They're not making the final selection. And I would say probably they're not even approving the final selection. Now, I don't have any experience with ESD boards that they are so removed that they have no involvement in the contracts that ESD makes. Even if the staff develops everything related to that contract and then just presents it to the ESD board for final approval, that's 1295 activity.
Okay. We've got time for maybe two more really quickly. A foundation gifted 2 ambulances to the ESD. Can one of the board members of a foundation be a member of the ESD? It's kind of...
Well, again, that's not an HB 1295 issue.
Right.
It would be interesting to see, if that's even a contract under 1295. I think as threshold question, I would say it sounds like it is, because there's probably terms with regard to the deployment and maintenance of that gifted apparatus. As far as the 170, 176, I mean, you're going to drag me into that area anyway. The answer is probably yes. However, there has to be disclosure. I'm not talking about 1295. I'm talking about disclosure under 171 and 176. Abstention by that person on probably both the ESD board as well as the foundation to make sure that the activity is being done by those entities themselves.
Okay, we got time for one more quick one. This is the open carry. Well, you kind of addressed this. This came in before that. What if you're meeting at a school or a courthouse or somewhere that's exempted specifically? Open meetings are generally exempted, right? And then if your ESD meeting is exempted from open carry, right?
Right, and the thing to be remembered with regard to that, as well as the courthouse exemption, is that the exemption to being able to bring in a weapon into those locations is limited to that space. The fact that you're having a meeting of an ESD or a city council or a county does not suddenly make that entire building inaccessible by open or concealed carry persons. Same thing with a courthouse. If it's a county courthouse like we have here, where essentially it's all courtrooms, yeah, possibly everything except the first floor may be unavailable for open or closed carry. However, if you have a single courtroom, for example, in some of the courthouse annexes, where there's a JP court and then you have the tax office and other offices, it doesn't necessarily apply to that entire building. Certainly to the courtroom, but then the Texas Attorney General has said that if there is other government functions going on, that is not an automatic prohibition for open and closed carry.
Okay. I think that's pretty much our time for tonight. Thank you, Howard, for all that good information. Thank you all for joining us.